the honors of introducing Viona to the ladies, and then she can go ahead and start right after that. Thank you.
Okay, thank you, ladies, for joining. I can see more people are joining. I see people are also inquiring about the link on our WhatsApp group. So if Brenda or Jackie or Lydia or anyone can keep sending the link to people, that would be fantastic. Thank you for joining. We're privileged to have Viona here with us. Viona Ochola is an advocate. I usually don't know how to introduce advocates. I get very nervous that I'd say the wrong thing, but she's an advocate of the High Court of Kenya. She's here today to talk to us about conveyancing. So how do you go about buying property in Kenya? A lot of us are in the diaspora, some of us are in Kenya. We are very scared to buy land, to buy property, because we see someone will steal from us. We always think, oh, Ibrokwala, people, I'll be conned and things like that. So Viona is here today to maybe lay our concerns at peace and give us direction. How do we go about buying property in Kenya? What is the legal steps we can take to actually ensure that when we purchase property, we are either not conned, we are not sold property that's owned by someone else already, or other those wild and wonderful things that we hear about in the news. Thank you, Viona, for agreeing to do this today, and welcome. The floor is all yours.
Well, thank you very much, Irene, for that introduction. You didn't say anything out of the ordinary, very, very much within scope. So yes, my name is Viona Ochola. I'm an advocate now, 13 years practice, mainly in the space of real estate, and I do litigation as well, based on the outcomes of some real estate transactions that have gone wrong. So that has helped me to really learn how to structure um, real estate transactions and contracts, because of having to see the dark side of things as well when you are drafting new contracts. So yes, when I heard I was coming to do this talk, conveyancing is a very, very wide practice. I will try and summarize as much as possible, and then take up questions which would make me elaborate on areas which I may have left out. So for those who may not be so familiar with this word conveyancing, basically it's just a process of transferring ownership of property from one person to another. And it also includes the process of loaning and getting securities registered against properties to be able to take facilities or loans, using the properties as security. So basically, the process of conveyancing has seemed complex in Kenya, and one of the things that has uh, contributed to this status is because for so long we have had various laws, different laws, about 5 regimes of law that apply to matters land. And that caused confusion, because you would be in an area, and you have your title having its domicile, or rather using a particular law, and your neighbor has a property which is domiciled in a totally different law. Your titles look completely different. You guys go to different registries, and this is your direct neighbor. So that kind of status led the country to, in the 2010 constitution, to streamline the practice of conveyancing and merged all the laws into the Land Act and the Land Registration Act, which are currently operating. So that's where the legal framework currently is. So all of this is based on that law. So I'm just hoping that today's talk will be able to enable you look out, have items to highlight to yourself, to look out for when you are purchasing land or property in Kenya. So at the very beginning, what you need to do when you are thinking about buying land, when you feel like you have identified the kind of land or property that you want to buy, is always consult an advocate first. I know people don't like hearing that, but sometimes it saves you more time. It saves you money as well when you have it as a start point. Once you have identified the land, you have probably gotten in touch with the person who is selling. The next thing to do would be to reach out to your conveyancing lawyer of your choice. Um, it would be good to look for a lawyer that does conveyancing. I would say so because not all lawyers in Kenya practice real estate. You would find a lawyer doing mostly litigation and court matters, but he's very good at that, but they are not very familiar with the real estate practice. And some of the things that a real estate practitioner would be able to point out in your transaction, somebody who isn't in the day-to-day business of doing real estate may not be able to see. Not that they can't do it, but they may end up not looking at things with the kind of scope that a real estate practitioner would. So once you have elected a conveyancer to do your transaction for you, the next thing then the conveyancer would do would be to do due diligence. So due diligence basically is looking into the property, looking into the title. You are looking at the seller. So three things you are looking at when you are is the title right? Is the seller really the seller? And is the property the real property on the ground? Is it okay? So those are the three questions you ask yourself when you're doing due diligence. So for the title search, is this will be done at the land registry where this title is held. So most times it would be at the local registry or at Nairobi. And Nairobi has a central registry which sometimes has titles domiciled in other counties that are not Nairobi. So the title search, your advocate should be able to get for you the title search. And this is the shallow title search. We have a registry search. Most times you may have heard of this thing called a root search. Yeah. So a root search is different from a title search because it gives you history of the previous transactions that have happened on that property. So you are able to tell these are the previous owners. I think it usually goes back to the last three owners. These are the previous owners who have owned this property, and you never know what that will bring out. You may not like some of the names that you see there. You may want to question the outcome of these searches once you receive them. So the title search should be able to tell you who the owner of the property is. It should be able to tell you if there are any, we call them encumbrances, registered on the property. So an encumbrance would be any rights that any third party has on that property and has registered that. So that encumbrances would be things like a charge, a bank which has given a loan on the property. You should be able to see that on the search. A caution registered, somebody who had some third party interest on the property. An easement. An easement is a right of way. Somebody has gone and registered a right of way through your property. Such things can only come out through the title searches. Part of the due diligence would also be verifying the seller. So if the seller is an individual, that verification would mean you ask for the identification documents. There's always a way of verifying whether they are authentic or not. And if the owner is a company, then you would want to do searches at the company's registry to know who the shareholders of that company are and actually whether the person you're dealing with or the person you're speaking with is actually a member of that company. The next would be the survey process. This is now the actual land on the ground. You also want to check whether this land is good for purchase. You'd want to know where its boundaries start because the owner may be showing you its boundaries, but those may not be the correct boundaries of the property. So you'd want to know the boundaries of the property are okay. You'd want to know the acreage of the land to just confirm whether the neighbors have encroached, whether the land is the one that has encroached on the neighbors. And at this point, I would want to give you an example of a transaction I had with a client of mine at some point in a place called Ruiru here in Nairobi, where my client was taken to the ground by a seller. And he was shown very good land and he was given a copy of the title which is in the name of that seller, and that seller also gave the identification documents. And when I insisted to this client, survey is usually optional. To a client, I give it as an option, but you can choose to do it or not, depending on your circumstances and funding as well. So when we actually did a survey, we figured out that the land that our client was shown by this seller is not what is actually on the title, because the surveyors are able to take you to the actual land. So for purposes of the costing of that transaction, the purchase price was higher because the land was next to a tarmac road. Whereas the actual title which our client was given for due diligence, which we were actually going to put in the agreement and eventually transfer, was way inside. So it was like 2-3 kilometers. So the price of that property definitely would be different. So survey process is usually very crucial for me. It averts some of those problems that you would have inside the transaction. It makes you have some difficult conversations with the seller way early in the transaction, or maybe you can even choose opt not to purchase. It's an expensive process, so sometimes some people would want to do it within the agreement after they have already committed to buy it. But most times I propose that you do it early in advance. Some other special due diligence that is also necessary, not in all circumstances, but when your land borders a river or a water body, when your land borders an airport, when your land borders a railway line, it's very crucial that your advocate approaches. If it's the railway line, you approach the Kenya Railways. If it's the airport, the KAA, that's Kenya Airports Authority. If it's a water body, you are approaching WARMA, which is the water regulating body in Kenya, just to find out how far the boundaries of the water bodies and these other organizations go, just so that you don't find that your property was one of those that was ever either in the buffer zones or require consent from these organizations. You may also find, and this is very crucial, particularly when you're buying land for a particular purpose. I saw this happening in a piece of land that was next to the airport in Kisumu, where our client intention was actually to put up a flat, and a land that is third in row to the airport. By the time we were doing our due diligence, going to ask for consent from the airports authority, they told us we could do flats, but nothing more than 2 floors. So you can imagine, for that client, it was such a disappointment, because now they have a property which they cannot use for the purpose for which they had intended. So when the land is in those parameters that I have mentioned, it's very important that that you ask your advocate, or your advocate leads you to look at this other organization for consent, and just a surety that whatever you want to do with the land can actually be done. Once the due diligence process is finished and you have confirmed the title is clean, the land on the ground is okay, the seller is verified, then the next thing to do would be the sale agreement process. Yeah. So this is where the commercial terms that you are agreeing with the purchaser, with the seller, come into place. What have you agreed as the purchase price? What is the payment plan for the purchase price that you have chosen? Where is the money being paid? So most times this will be structured by your advocate, but the standard terms of most agreements is usually that you pay 10% of the purchase price on signing the agreement, and the balance, which is 90% of the purchase price, on completion of the transaction. And the standard time for completion is usually 90 days. Yeah. So those commercial terms are not cast on stone. It all depends on your availability of funds as a purchaser, and for the seller, it depends on the availability of documents on their side. Yeah, and this process also depends on whether you, the purchaser, is getting a financing for that purchase. So for instance, if you are a cash buyer and you have the money for the purchase price upfront, this is a transaction that can even take 30 days. But if you are planning to get a loan, you negotiate for more time, so that you don't find yourself in a place where you have defaulted on the payment terms. So you can always structure the payment terms on that. On that, I usually say, whenever you look at an agreement, insist that your purchase price is paid directly to the seller's account. And I say this for different reasons. I have had circumstances where a seller verbally tells you to deposit money somewhere else that is not his account. And eventually, when there is a default, they would come and reject, or rather deny that those funds were ever sent to them, or sent to them for the purposes of this agreement. So I usually insist that purchase price be sent directly to the purchaser who you are dealing with, the seller who you are dealing with at that point in time. And most times pay to a bank account so that you keep details of the transaction for future reference. Not only for your verification purposes of payment, but these days even for our Kenya Revenue Authority, you never know when they come digging into things, and just to find out whether the purchase price you paid was actually in the amount that you are talking about. Yeah, so once your sale agreement is ready, it has been signed by all parties, the completion period has come. We are now talking about the transfer of ownership process next. That's the next step, where your advocate again should still be able to help you in this, and to ensure that you receive from the seller or the seller's advocate all the documents that are necessary to transfer the property to yourself. So most times this set of documents would include, most importantly, the original title, and the transfer document signed by the seller. Very, very important to also have the land control board consent. It's also important to have the land control board consent from the land control board. The reason why I'm hesitant there is because not all circumstances is the land control board required. It's only for some properties. And the spousal consent, in the event that somebody again isn't married, there's usually a different document that we prepare, an affidavit, where somebody swears to confirm that they are not married. Yes, just so that you cover yourself. If the property is rateable, like the seller has been paying land rent or land rent on it, then it's also important that they give you the land rent receipt for at least the past 3 years for your records, and a clearance to show that by the time they're selling to you, they are in good books with the county offices. Yeah, so far that is it. Your advocate again should be able to do the registration process for you. That will entail paying for stamp duty, and then the registration complete. Let me just say it completes. There are a lot of rigors of what goes on in the registry, valuation of the transfer, stamping of the documents, but eventually the last process that the advocate is going to check into is that you get a title that has your correct details to ensure that your name has been spelled rightly on that title, and then to also ensure that the property, the physical property, is handed over to you with vacant possession, to mean with no squatters on it, to make sure that you are not taking up tenants or squatters on the property who were there when the seller was selling to you the land. So very, very basically, the important documents in a conveyancing process then would be the sale agreement, the title document, the transfer forms, the land rate clearance certificate, and then stamp duty payment receipt. At the end of a transaction, those are the 5 documents that you would always expect to have at hand, particularly if you are buying. So your responsibility as a buyer in a conveyancing process is purely financial. That is payment of the purchase price. And the seller's main obligation then is to hand over and pass a good title to you as the purchaser, and then to hand over the physical property to you in good condition. The lawyer's main role would be to facilitate the whole process, ensure that the law is being followed through the transaction, to vet the documents, to vet payments, and then just to make sure, again, that the property is handed over to you in a good state. Definitely, like you have mentioned before, there are challenges in this process. It's not as smooth uh, flowing as I explain it. There are times when title disputes may arise in between a transaction. For instance, you go on ground and there's a dispute. Somebody who doesn't have a title claiming they own the property, when the title is in the person whose name you are selling, whose name, uh, like the name of the person who is selling to you. There are usually challenges also on delays in the registration process at the land registry, which sometimes are not things that are in your control. For instance, you find a registry is closed or is understaffed, um, and then just prevention of fraud. Uh, there's a lot of fraud around land transactions. So those are the challenges with the entire conveyancing process as a whole. Something that I know many people want to ask is about the cost. It's always prudent to get a quotation from your anticipated provider. So by a provider here is the advocate that you'll be using. Get a quote. Generally, the cost of conveyancing from beginning to the end would cost you between 7% to 8% of the purchase price if you are estimating how much to put aside. And the cost would include legal fees for the advocate who you hire. Our fees are usually guided by the advocate's remuneration, though there's a lot of negotiation that also goes into that. But averagely, it's at 2% of the purchase price. Stamp duty. These are tax that is usually paid by the purchaser on the transfer, and it's paid at a rate of 2% or 4% of the purchase price. The difference on whether it's 2% or 4% depends on the location of the property. 4% is mostly for properties that are in urban areas. Very, very recently this year, when our government was on a run to increase the taxes, the government increased the band on properties on which 4% stamp duty has to be paid. So right now you'd find some properties which are in the peripherals of an urban area are also being charged stamp duty at 4%. And then there are the registration fees, which are official government costs that are payable to the lands registry. These are not usually much, and averagely it would be about 5,000 shillings. However, due to our bad manners, I would call it bad manners and corruption, mostly at the lands registry, there is usually need to facilitate the process. And that may lead to you paying much more than the 5,000 shillings for registration. There is value added tax, that's VAT. If the property you are buying is a commercial property, that means it falls within a commercially zoned area. Or if the property has been like a change of use has been done on the property and the property is selected or set aside for commercial purposes, then the despite above the purchase price that you will pay, there will also be VAT that is payable back to KRA, and this VAT is usually the responsibility again of the purchaser. If you are selling land on your side, then there is a tax called capital gains tax at 15% of the profit that you make that is payable by the seller. This is not a concern of the buyer, but if you are on the other side and now you are selling, always anticipate the 15% capital gains tax. There are exemptions for it, but only when you fall within the exemptions can you avoid it if you are selling land. Lastly, another cost is usually for the land control board fees. This is usually again payable by the seller in a transaction. But in some circumstances, I see purchasers negotiating this rate with the seller, and this cost as well also went up within the year. And now it's between 10,000 shillings to 15,000 shillings, down from 1,000 shillings So it's also one of those things that has cost the cost of transacting in a conveyancing process to really skyrocket. So the process I have just explained to you is where you are transacting basic land, yeah, where it is just land that you are transacting. The process is different when you are buying a house, not very different, but you just tweak it a bit. If you are buying a house, let's assume land that has a house built on it, the due diligence for such a scenario would be a bit deeper, because you may want to now go into looking at the structural plans for the house. You are looking at whether the bills for the house has been paid, because you don't want anything that is in the historical background of such a house to carry forward with you when you take up ownership of the house. I would also want to particularly explain about off-plan apartments. I don't know whether you would want me to talk through, or before I go into explaining the process of purchase of apartments, if there are any questions that would come in at this point. I don't know how we can go about this, Irene.
Sorry, someone else. Jackie, I think Jackie was going to speak. I'll let Jackie speak.
No, I was going to say, go ahead with with your presentation. If there's any questions, ladies, you're welcome to put it on the chat, and then maybe at the end of our session is when we can have our Q&A to for us to ask any questions additional questions we have. But I'd say go ahead.
Very well, very well. So very special in the process of conveyancing is this new process, not so new, but the purchase of apartments in Kenya. We have had a model called off-plan sales, where buyers are getting to buy properties before they are built, or before they are fully built, or in the very early stages of construction of the apartment. So you are buying an apartment before you get to see the look of it. And it's just not apartment. It may also be a maisonette or house, or a house, but in kind of an estate, or a larger development kind of scope. It's not usually a one-off, like somebody just selling you a standalone house off plan. No, this usually happens in a larger scope of setting in a development. Yeah. So I usually say there are benefits of off-plan sales, or of off-plan purchases of property. And one of the benefits usually is that you get to buy the property at a lower rate than what the actual market value of the property is. And with that, then there's usually the expectation that, by the time the property is complete, there will be capital appreciation. And that would mean that if you sell your property at the time at which it completes, then you've made a profit of sort. But besides the benefit of it, okay, one of the other benefits as well is usually it also allows you a stretched out payment plan, as compared to a complete apartment, where the owner of the apartment may want you to have a shorter payment period for the purchase price. Yeah. There are, however, very substantial risks again with this property purchase model that usually require that you again as well have an advocate to help you to mitigate the process. But it's also usually good, like for this training, you just get to know, even before you consult an advocate, at least you have some things in your antenna whenever you are going into such purchases. Yeah. So what are the characteristics of an off-plan arrangement? So the first is usually that it's a pre-construction purchase, where a buyer is committing to purchase a property before it's fully built. Most times in such kind of purchases, you'll find the developer, who is your seller, is getting financing to develop this large scale estate. And most times the developer will be using the funds that you pay to them in installments. They'll be using those funds to do the construction. So part of their financing may be coming from a bank loan, and most of the financing they usually hope comes from the sales. Most of them usually go for bank financing in case there's a shortfall in the or a slow uptake of the project by purchasers, and they take financing so that they complete the project quicker. Yeah. Another characteristic of off-plan sale is usually the payment structure, like I had mentioned, where you are allowed a longer period of time to pay in installments. And most times the installment payments concur with the stages of construction. Yes, so that is usually one of the benefits again. And then, like I also mentioned, discounted prices. Yeah. So the legal framework for governing off-plan purchases in Kenya. Currently, there is no specific law uh, that governs off-plan investments in Kenya, and we are hoping as lawyers that some of us, I don't know, even I feel a bit guilty when I'm saying this because this could be me. We should be preparing for very, very specific laws to govern off-plan investments, because it's also an avenue for a lot of fraud in the property sector here in Kenya. Currently, we are purely relying on the land laws as we have. That's the Land Registration Act and the Land Act and the Law of Contract Act and the Sectional Properties Act, but they are not very specific to the model. That's why there is always a gray area that's not provided for in the law that allows some of these unscrupulous developers to take advantage of purchasers. I would want to give an example just to bring into the picture why this set of off-plan investments is very crucial. A case study: there was a developer at some point called Willow Park Limited, and they had a development in an area called Ruaka here in Kenya. Again, they took financing. I think when the uptake of the project wasn't that quick, they took financing from Jamibora Bank then, and they built the unit, yeah, to completion. Yeah. However, they failed to repay Jamibora's loan in good time, and Jamibora had taken a security against the mother title on which this apartment had been built. Yeah, remember, there are people who've completed payment. There are those who are still ongoing with payments. After back and forth, Jamibora decided to foreclose on the entire project, and Jamibora now started reselling the apartments that had already been sold off to purchasers who had bought off plan. And when they went into court, the court recognized Jamibora's rights being in priority to the purchaser's rights, despite the fact that the purchasers already had contract. Yeah, and it is because the bank's rights were registered against the title, and part of those rights gave them that opportunity to come and foreclose and sell to recover its unit. So that left the purchasers really exposed, because then the purchaser can only go back and claim against Willow Park Limited, and that just brings into this space, the kind of risk that off-plan sales can cause to a purchaser who is intending to buy. Most of them go through well, but some of them can usually end up very, very disastrously. Yeah. So in another case, again, another very unscrupulous developer called Banda Homes. Banda Homes did not take a loan on the management on the mother title. What Banda Homes did, it collected deposits from off-plan purchasers. They were doing sort of affordable housing, where an entire bungalow, a 3-bedroom bungalow in Kikuyu, was costing about 4.5 million, a very good price for the area. And most people ran to buy into the project, and people paid fully, some partially paid, but they only did foundations. They never went beyond doing foundations. So at some point, people started asking, the buyer started asking them, they finished paying, they are not getting their titles, they are not seeing their houses. This case is still in court. Purchasers are still trying to recover their investments 5 years, approaching 6 years down the line. So with those two kind of example, it shows you how much we have a gray area in the space, where the purchasers are very, very exposed and at risk when doing off-plan investment. So that brings into my next slide about the risks associated with off-plan investments. I've said it. So there's the legal risk, where you find another organization's interests have been registered before the purchaser's interest. Then fraud, like what is happening now with Banda Homes. Then there is also a risk of project delays. Remember, this is something you are buying before you see. You don't know what the construction market space is going to look like. So sometimes you would find delays are caused by lack of materials or strikes, or like there was a time there was no cement in this country. Yeah, like getting cement was a big deal, especially when the government was taking up more cement from the companies to do the affordable housing constructions. The other private developers were struggling to keep up with their construction schedules because of lack of materials. Yeah, and then quality concerns. Most times you are shown brochures. The people who come market these things very well. You'll be shown brochures, you'll be shown dummies on even how the estate is going to do, how the estate is going to work. And not in all circumstances will these units end up the way the promise was made. You may end up not liking the ultimate quality of what is handed over to you, and at that point you cannot pull out unless it is so drastic. For instance, if they were selling you a 2-bedroom house and it ends up being a 1-bedroom, like it has to be something extremely drastic for you to raise any quality concern issues. One other risk is about the uncertainty on cost. Like you saw in the previous talk, like in the previous conversation I'd had here about the cost of undertaking a sale of land. Some of those costs are very certain. That's not the case when it comes to an off-plan purchase apartment, and it's because the space is very unregulated. So you'd find one advocate charges you, let's assume 20,000 shillings to do registration. The next advocate will charge you 100,000 shillings to undertake the same process. So it is not regulated. It's not very regulated. So you may find your costs going much higher than the 7 or 8% that we had anticipated to spend in the purchase. And even so, most times, in fact, the practice in Kenya right now is that besides your own advocate's fees, you will also have to pay for the developer's advocate's fees. That's a practice that we created in this country. I've never understood why we are still trying to fight it. Most times I try to fight it, but it's a practice we created, that the purchaser pays for both the developer's advocate's fees and their own advocate's fees. So those are the risks that come up with these off-plan sales. And your advocate then would be coming in to help you to mitigate the process, to make sure that they vet the agreement beforehand, to make sure that you are protected. The normal due diligence process, like I had mentioned before. You may also want to vet the developer to verify their financial stability, to check their track record, to check whether there are any cases filed against the developer in the past, so that you don't find yourself going to a developer who already has a history of defaulting on a project. And then also, just your advocate should also make sure that the developer in this case has all the necessary approvals that are required for them to do the construction that they are undertaking. And then your advocate should also be able to negotiate for you a payment structure that works for you. Otherwise, these guys always have their agreements drafted in a manner that will not allow you to amend much. Yeah, that's again one of the unfortunate things with the off-plan sales because of trying to control the uniformity of the contracts that are entered with all the purchasers in the estate. They are usually, the developers are usually very rigid on the amendments that your advocate can make to the contract, but it's good to have your lawyer push as much as possible on the items which you feel are really ideal. And if you're not able to make any changes in those issues, like the issue of pricing, the issue of payment plan, the due diligence outcomes and all of that, then now you as the purchaser makes a very conscious decision as to whether you really want this apartment or property real bad, and that you assess on whether the risks are higher or lower. And then it's also good that your advocate also monitors the progress, constantly monitors the progress of the construction on the ground, to just make sure that if there are any delays, then yeah, these are highlighted to you in very, very good time. That is it with respect to uh, the off-plan apartments or property sales. I would just want to briefly mention something about properties in Nairobi, because Nairobi County properties are not um, treated currently. We are not dealing with them the same way as we are dealing with properties elsewhere in the country, and this is because of the new digital land management system that the government introduced for all properties within Nairobi County, and that's Ardisasa. You may have heard of it. It's a digital platform that the government launched to try and modernize and simplify the land administration process. It provides the platform provides an interface for citizens to access land related services. And basically, it was to avoid physical visits to the lands office because of the level of corruption that used to be there. But even as I say that, I'm saying it with a smirk on my face, because I feel like this system has brought about more corruption that there was even when we were doing the physical visits, because at the back end of the platform, we still have the same people who we were dealing with physically, and now unfortunately they are jamming the system, and you cannot proceed beyond a certain level before you want to find out who is working on your matter, and they are asking for even more money. So for Ardi Sasa, currently, if your intention is to purchase property in Nairobi, it would be good for you as a purchaser to register yourself on Ardi Sasa. The requirements for registration are your ID. You are required to have your KRA, a working email, a working phone number, Kenyan phone number that you can use, because there are some one-time passwords that are sent to both your email and to a phone number to enable you to access the RD-SASA. So what is on RD-SASA? Land registration process, title deed issuance, you can get your land searches there, even survey services are there, land rent payment. Ideally, the platform is supposed to be in such a way that even guys in diaspora are able to see the status of their properties here in Kenya under one roof. Eventually, it's a platform that will be rolled out to the entire country. But as it is, it's only Nairobi that I think is being used as a pilot. Eventually, the entire country will come into it, and from wherever you are sitting, you can always access your properties in this platform and see the status of each one of them. It is a nice thing, but I think we'll have a lot of work to do. We have a lot of work to do to be able to get to where the platform works optimally as it should. Yeah. So that is it for now. I believe I will clarify any issues that I may have left out. If there are any specific questions that you have, I would want to open up the floor for questions.
Jackie, do I read the questions out that are in the chat?
Yes, thank you so very much, Viona, first of all, for that totally clear presentation. And so, you have a lot of information for us. So definitely, Irene, I'll let you go ahead and monitor the questions and ask the questions also. And yeah, let's go ahead. Go ahead, Irene.
So the first question is from Gladys. I'm wondering if I can't see Gladys. Oh, Gladys is there. Gladys, do you want to ask your question yourself?
Yes, I do. Fiona, thank you so much for coming on. It's really greatly appreciated. I wish I had listened to you previously, but my question to you is this. I'm sorry, I had bought a land in my hometown, and the advocate did not get the requirements for me to proceed with the conveyance. So years later, I started bugging him to go ahead and get it. And he still did not get it. And in the process, somebody bought my land. Can I sue the advocate? And will you be willing to take this for me? Because I'm very bitter.
Okay. From what I'm hearing, you did not receive the instruments to enable you transfer the land to yourself. Did you have a sale agreement?
I did have a seller agreement executed by the advocate. The advocate counted the money and handed over to this lady. That's why I feel that he actually did let me down.
Okay. So there are avenues, because what you're talking about is professional negligence on the part of your advocate. And as advocates, we have a forum where displeased, dissatisfied customers like yourself, clients like yourself, can go to. That's the advocate's disciplinary committee to lodge your complaint against a specific advocate, particularly for negligence and the losses that you countered for that kind of negligence. The way the process starts, there is no much legal representation. So, for instance, if you choose to go that path, the starting it would be a direct involvement by yourself to the disciplinary. You don't need an advocate at that point in time.
Oh, thank you.
Yes. So because now they need very, very direct information from the person who was aggrieved. And then also looking that, this is a fellow advocate. I think ideally the process was done like that so that you don't feel like advocate to advocate. There is something I am not relaying to the disciplinary, which we would prejudice my fellow comrade, my fellow advocate. So that's why they prefer the starting of the process to have you as the complainant go in to report. I would, however, caution you that this. I as an advocate, I know I'm saying this, but I do not trust the process. And most times, I would rather if you had proper documentation. And by proper documentation, what do I mean? Most times, even when you are engaging an advocate, and this is also something to look out for, it's always good to insist to have an engagement letter with your service provider, being an advocate, um, before they even do something for you. Unless it's an advocate who you have worked with over time, that there is no need for an engagement letter. If it's somebody that you're dealing with for the first time, that engagement letter serves you very right as a client to show that you had engaged this person and to what extent you had engaged this person, because then the engagement letter should be able to have the scope of the work that the advocate was to do. Because then in the absence of a contract between you and your advocate, it's your word of mouth against that advocate's word of mouth. And that's why in most cases in these disciplinary processes go unresolved, or they take too long because it's your word against mine. So who should they believe? Um, so just as a caution, you still have an avenue you can go to, but for future reference for all of us, whenever you are appointing an advocate, it's always good to ask whether you can solidify that kind of arrangement in an engagement letter. But so sorry for that.
Because the case is in court and I'm still pursuing it in court, do I have to wait until it's done, or I can just launch a complaint right now?
You can lodge a complaint concurrently with the case ongoing, because I want to imagine the case in court is not against the advocate, it's against the person who you bought the property from.
Correct.
Yes, so parallel to that, you can sue your advocate for negligence. I don't know what your financial claim will be for that, because the ultimate of such a claim would be either this advocate to be disbarred so that they cannot practice anymore, or for them to be suspended for a period of time to punish them, or to pay you some level of compensation. Yeah.
No,
But
the compensation I want is for taking the case to court now. If he would have done this, I would not have been there. So I want him to pay me every dime that I've used to take the court to court.
What I foresee with that kind of a scenario is that there'll be, I want to call it double jeopardy or double benefit on your part, because for the case that you have filed, assuming that you win the case, ideally the court should also assign to you cost of the case, so that the person against whom you have filed the case, not only will they refund you the money you paid for the purchase price and interest on it, but they should also pay for your cost for filing this case in court. That is if you win the case. But if you lose the case, then definitely it is a claim you can make against the advocate. But you can't make the same claim in court and also against the advocate in the disciplinary committee.
Okay, thank you. I will look for the link and actually do that.
Okay, very well. Thank you.
Thank you, Viona. The next question is from Susan Oweno. Susan, do you want to ask your question? Or do you want me to read it? Okay, I'll go ahead and read out Susan's question. So Susan is asking, she has a house. If she has a house that she wants to transfer to her child as a gift, what would be the procedure or requirement?
Okay. So is the child a minor, or I would want to know if the child is of age of majority 18 in Kenya, just to find out whether that process is possible in the first place. Okay, assuming the child is of age, yeah, the process would be quite the same as if you are purchasing or selling to somebody who was purchasing from you. The only difference would be that there is no consideration, there is no purchase price passing. And just to be a bit cheeky, because I know most people think that when they transfer a property as by way of a gift, there'll be no stamp duty requirement in terms of payment, but the process is the same. In terms of drafting transfer documents from you to the child, you still draft transfer documents. If there are any consents that are required by the land registry, the land controllable consent or any other consents, you will still need to get those. If there are clearances of rates and rent that are required before you transfer, you still need to get those. In terms of stamp duty, stamp duty will still be paid if you are transferring the property directly from yourself to your child. However, as advocates, we usually ask our clients, depending on what you really want to do, but the stamp duty amount can always be avoided. What you do is that you set up a company with you and that particular child as the shareholders of that company, and you transfer this property from yourself to the company, stating that this is a family company. There is an exemption in law whenever you are transferring a property from yourself to a company that is a family company. That's a company that has its shareholders as husband, wife, husband, children, wife, children. No, not cousins. Cousins and uncles are not included, but just the nuclear family members. Then there's an exemption there. There's also an exemption if you're transferring a property from one spouse to another spouse, but there's no exemption if you're transferring property from a parent to a child or from a child to a parent. Yeah, but the process is the same in terms of documentation that you procure. I don't know whether that answers you, Susan.
Yeah, Susan. Susan, does that answer? She's not responding. Follow up to Susan's question is, how is the stamp duty determined, given there's no purchase price?
Okay, so part of the process of registration, and this is not just for this transaction, for any transaction, part of the process of registration, when you take the documents to the lands registry, the first thing that happens is that the government always has an investigating officer, the person who vets your signatures. Apparently, they usually keep a record of the signatures of the person who signed before and the person who's signing now. So that person does the investigations and verifies. The next stage is a valuation process. So you have a government valuer who will either go to site of the property and give a valuation, a current market value of the property, or if the value rate of that region is already known to this valuer, they don't need to visit site, they will give the property a value. And the reason why the government does this is that me and you may decide, I'm selling to you a property that's worth 10 million. I will sell it to you for 1 million, or for tax purposes, I will indicate in my transfer that the property is 1 million. This will lead to the government losing money in terms of stamp duty amount. So what the government does is that it has assigned its own government valuers to value all properties in respect to all transfers, and then do assessments of what the stamp duty will be, either at 2% or at 4%. So that will be the value. Once the valuation has been done, that will be the value that will be used to assess the stamp payable in that transaction as well.
Thank you, Viona. Jackie, can I hand it back to you to now take questions? We've finished the questions in the chat.
Are you the place where you can continue? Or you the?
I think there's one more question in the chat, but I'll let Brenda, then Damaris speak, then I'll go to the question in the chat.
Okay, thank you. The explanation, I'm glad that the person, Susan, brought up that other question before. That's very interesting. Now, my question is a little bit different. So my mother bought a house in Nairobi, and while she was alive, she took a loan with the house as security, and then she passed away. So the insurance paid for the house, and for some reason, the bank is stuck with the title, saying that there was some amount that she had defaulted on while she was still alive, and they refused to write it off. So I decided to pursue it and kind of see if I can buy the house. So first of all, we've completed the succession. My father and brother are the estate administrators, and I have signed a contract with my family, them allowing me to cover whatever cost is outstanding and then, own the house. From a legal standpoint, because I intend to take a loan, a private loan, probably a mortgage to offset the amount. From a legal standpoint, one, is the bank, does the bank have a right to claim money on somebody who's not alive and bought it in the individual capacity? Then number two is, what else do I need to look out for when doing this purchase? Like what do I need to consider? I've never done this before. I just kind of want to see what else I need to be thinking about other than me signing a contract with my family and then me looking for money to buy that house.
Okay. Yeah, thank you, Brenda. It's very unfortunate. This is actually the second case I'm hearing, or rather getting, where the bank is holding a title as lien for funding not received. So basically, whenever there's a mortgage, like you rightfully said, part of the repayments that are done once the homeowner is deceased is by the insurance. In fact, the insurance, one of the things that you do whenever you're taking a mortgage is that concurrently with the mortgage, you sign an insurance contract for purposes, and your remittances, your monthly remittances, part of them actually goes into insurance for such eventualities. So I don't know whether it is still an issue, whether you'd want to contest with the bank, because for me this would be something that I would want to contest. Whether the bank is giving proper foreclosure, it's disclosing exactly what they need to be disclosing, or they are just telling you what they need to tell you. Because in my view, if insurance cleared the loan, they cleared all the loan, including any arrears that they are saying that were not paid on default. And the reason why I say so is because if there was any default, they ought to have sent notices to the person who is defaulting. They need to show you that they sent those notices to your mom, and
So they did
insurance,
not.
So I don't know. It seems to me that you may have resolved to proceed and pay off the amount.
Actually, on the contrary, I decided to engage a lawyer who charged me certain percentage. So we agreed that he wrote them a demand letter, just kind of telling them, so it gets worse. They even continued accumulating interest on the amount that was outstanding as at the time my mom died. So even up to now, they're still piling on interest on that amount. So I think I was advised by somebody that it's illegal what they're doing. So I decided
which bank is this?
Kenya Commercial Bank. So I decided to pursue the legal bit where I wrote a demand letter through the lawyer, and we're kind of just waiting. So they said they were going to get back to us at some point. But it's very unfortunate, like you said, that they not only retained the title, but they're continuing to charge interest even as we speak. And it's not just interest, they're charging the penal interest, whatever it is, when you're not able to pay. So I think it's a wait and see type of thing, but I'm guessing they're going to come back with some type of figure for me to pay, at which point, I think. But I don't know what else to think about in terms of the transfer of the property itself.
In terms of the transfer of the property itself, you've said the succession process has been completed.
Yes.
So I don't know whether in the confirmation of grant, you are the one who is getting this property, or you are planning to buy it off the eventual beneficiary under the succession.
Yeah, it's a percentage. Each child is getting a percentage. But what's happening is, because of whatever other legal fees and processes that have paid, my siblings are actually signing a contract with me to be able to transfer the house to me upon me paying off whatever the bank decides that we're to pay off in the end. So I do have a contract with my siblings on that. Yeah.
There is not much really to consider at this point, besides, because now this is internal, it's family to family, and the history of the property is well known to you. So besides land rent and land rent, I don't know the type of title that you have, but I'm just thinking about land rates and land rent. And then since all properties in Nairobi now are under RD-SASSA, it may also be good to know that the process of registering they're usually transfers that are registered from the deceased person to the administrators and then to the beneficiary. Then now the beneficiary will be assigned, will now have to transfer to you. So you must be ready to wait for a process. And I know this RD-SASSA process has not been very clear, particularly about the movement, the transfer of property from a deceased person to the beneficiaries. I have one that has taken me 8 months and it's not complete yet. So it's good to know about that waiting period that you may have to wait while this property is moving faces, and then also just to verify it on Ardhi first. Yeah.
Okay, so that might also affect if I'm taking, for example, a mortgage to purchase it, quote unquote.
Yes,
It
yes,
will
yes,
also
yes.
affect that part.
Yes,
So,
because you
okay.
can, and you know, even your financial may end up not accepting to take it because they know
Mm.
what a
Oh boy.
redisasa process means. And before now, you get to a place where now the bank's charge is being registered against the property. The
Mhm.
first transfer from the deceased person to the administrator needs to have gone through. The second transfer from the administrator to the beneficiary has gone through. Then now the transfer to yourself has gone through. Then now the charge is registered. You see, those are 4 processes.
Mm. Mm.
So in
Wow.
terms of
Okay.
length of time, your
Mhm.
financial must be ready
Okay.
to foot that bill. But I'm happy you're in a
Mhm.
Sacco, so I'm hoping your Sacco so cute.
I hope so. Yeah.
Yeah,
Thank you.
yeah, welcome.
Damaris?
Yeah, thank you, Viona and everyone. Viona, what entity do you think is the best when people are buying property or land or a house as a group? What would be the best kind of legal entity? And if you're able to share the reasons why and why not, that would be great. Thank you.
Yeah, I have had this question asked a lot, especially by Kenyans in diaspora. For me, the best model is always a company, provided you have a very, very clear constitution or shareholders agreement or articles of association that shows how members can leave or join the company. Yeah. But for me, a company is the most regulated kind of avenue where both the members, all the members will feel protected. The reason why I say so is I have had members coming to me with self-help groups, and those don't work because they don't have a legal framework here in Kenya. And because of that, you cannot verify them. So if today you have a self-help group and it purchases a property, the title will be registered in the name of the officials as trustees for the self-help group. And the challenge I have seen with that particularly is when you find an official leaves the self-help group and the title was registered in their name. How to move this property remove that person's name from the title now that they are not an official is a big task, because what the land registry is asking for, they're asking you to bring verification from the registering body of that self-help group to confirm who its current officials are. And because of the way these self-help groups are not regulated, there is no way nowhere you can go and search for it. There is no list of members. It is just a mess. So for me, I usually say the best avenue to go about this is a private limited liability company. Some people like to do partnerships, but for me, partnerships are complicated again because of the fluidity of them. And also when the members are more than 2 or 3, then it befits purpose to do partnerships. So it's better just to go by way of a company.
Thanks.
Welcome, Damaris.
Okay, the next question is from Achieng. Achieng, do you want to ask your question or do you want us to read it from the chat? So you can offer clarifications. Okay, Achieng has chosen for it to be read. So what are the requirements for a spouse if a spouse would like the name of the other spouse added to a land?
Yes, the main requirement is usually the marriage certificate. The marriage certificate to confirm that you are indeed spouses. And the reason why that is the core document, in fact, the registry usually asks for the original. They return it, but they usually want to see the original marriage certificate. First, they verify for themselves and then they'll give it back to you. The reason why they ask for it is because that process comes with a benefit of stamp duty exemption as you are doing the transfer. The requirements besides the marriage certificate is the transfer document. So there's an actual transfer document where the spouse whose name is on the title is transferring the property from himself to himself and his spouse. So it's an actual transfer, but the property is moving from one person to joint persons. So that's usually the main document. In terms of land control board, in case if the property is in a region where you have to get consent, then the relevant consents like land control board consent would still have to be procured. It doesn't have much requirements except the marriage certificate and of course the documentation, identification documentation for the two parties, and then the signing of the transfer document. And of course the financing. Now that stamp duty is exempt, then the only cost you'll be paying then is your lawyer's fees and the registration fee.
Thank you, Viona. I don't know if Achieng, you're satisfied with that answer. And I'll ask a question. So when one is buying land in the rural areas, usually you go to a chief or an assistant chief who gives you this form from Ministry of Land, and you fill with the person, and then you sometimes, if they're an old lady, they put a kidole. Are these forms legal?
They are very illegal.
Okay.
I would want to say they are very illegal. Because you see, it's land. It's land anyway. I think what the chiefs are trying to achieve is meeting a requirement which the law requires, which is that all sale of land, all transactions relating to land should be in writing. So what they're trying to achieve by giving you that form to fill is by meeting that requirement, just meeting that that bare minimum requirement that this needs to be in writing, not that it is right, and not that it covers you very much. That document can assist you whenever there's a dispute because it is in writing and you can use it to make any claims in a court of law, but it is not it's not in the chief's place to do what they are doing. In the rural areas, it is good to notify the chief, but if the property has a title, most times I see people doing that for properties that do not have titles, but that doesn't hold water much because at the end of the day, when you come to court, you'll be asked whether this property has a title or if it doesn't have a title. Yeah. But even as we say so, I think there's something that now that you've mentioned rural areas, I need to highlight, and this is with respect to matters arising out of succession. In the rural areas, we have a lot of that. And we are always having this case where the person who is selling to you is a beneficiary, a dependent of deceased parents or deceased grandparents, and they're telling you, "Hii property ni mimi niliwachiwa." Like, I am the only son in that family. You know, that those kind of conversations, yeah? And I know many people fall for them. But it's one of those things that you really either need to steer off from because currently Kenyans are very, very knowledgeable. And I know in the past, uh, most people thought, and even like most ladies thought, and even our male counterparts, that ladies were not to inherit. And I know in the cultural setup, ladies are not to inherit from their parents. But that's not the law. If today a lady is disinherited by her family, she can always go to court and in the succession process claim to have something divided for them in that succession matter. Yeah. So it doesn't matter whether the property is up country or what. If you are to buy the property from a succession, insist on the persons who are selling going through the succession process. That's when the truth about the property will come out. You will see female beneficiaries coming up to claim. You will see the property has been sold to one or two other three people, which you never knew that this person had received money from before. So I think the chiefs in most of the rural areas usually do whatever they are doing, like you said, Irene, just to try and cover that loophole, and also to give the purchaser some sense of security that, there's somebody and a government officer who knows what's going on. But if push comes to shove, their knowledge may not defend you so much, particularly when there are disputes that run deeper than just a confirmation as to whether you have bought or left or not.
Thank you, Viona. You've actually answered my next question, which was going to be, can I use it in a court of law? I will I'll hand over to Jackie. I think she has a question, but also...
Yeah, I have a question.
Yeah.
And thank you for touching on that ancestral land issues. So what trumps what? If like let's say the grandparent who is deceased had already had already demarcated different parts of the land. Can somebody come up and still fight that in a court of law and say, no, I don't want to do what whoever they inherited the land has passed away, and we don't want to do that. Let's divide it again. Let's demarcate it again. What reigns? So what takes precedence?
In my view, if the deceased grandparent, in as much as they pointed out, is there proof for that pointing out? Because that's an oral will. Like, looking at it from a legal point of view, it's an oral will where somebody in their life is saying, so and so take this place, so and so you will use this space, so and so you will take this. That's an oral will. And the proof of an oral will is you have people corroborating the oral will, people, or the oral will, people who are actually there when you are saying that. Because you see, you never know whether what was said was actually said. And if there, it has to be without any doubt. Such a thing needs to be without any doubt. And even when you go to the succession process to undertake, we call it intestate succession, where somebody died without a will, the way you propose to the court, because it's going to be you guys who propose to the court how you intend to distribute the parcel of land. If you guys choose to go with how the deceased person pointed out during his life, well and good. But if anybody comes to question, that person's query will take precedence because there was no evidence that this person was actually given this section and that section. The only thing that could assist is if during the life of that deceased person, this deceased person gave or rather distributed this land, which will now be considered as a gift during life, not inheritance, and that person actually built or took possession of the parcel of land where it was pointed out, you can always try to bring out, if you are that person who was shown a particular land, you can always try to bring out that aspect that even before this person died, I was already in possession of this section and they were okay with it. But if occupation of this land takes place after the deceased person has died, then that rearrangement can always take place if somebody comes to claim. I don't know whether I've answered. I feel like I've talked around it.
Yeah. So what I'm saying is, okay, the before the person deceased, everybody knew what he wanted, but now with the new law and women are coming and saying, no, he had said this, and we all know this is what he had said, but now because there's a new law, we want also a part, and when we're wanting a part, we want everything to be divided equally all over again. That's where I was coming from.
I'm saying it is very, very possible to challenge. Very, very possible to challenge, because even the persons who were shown during life, even the persons who were shown during life, for them to get actual titles for their parcels of land, what I am assuming is the larger ancestral land is still in the name of the deceased person. Now, for each and every one of these people to get their parcels of land, they still have to go through succession. And in that succession, they will still have to name all the children of the deceased person, whether or not these people are going to benefit from this land or not. So in that listing of those beneficiaries, which is work that the chief does, they need to list both male and female without discrimination. If they leave out any person, that person can come and claim for a redistribution of that property. Yeah. So and that's why the court usually wants to know whether everybody has been listed, and they will ask each one of you who has been listed there whether you are comfortable with this subdivision or this distribution. They will actually disregard the subdivisions that were done by the deceased person when he was alive, if there is no proof anywhere. If you guys cannot bring a chief who was there who confirmed that this mzee said that this person, or an uncle or an aunt who confirmed that you were there and this person said, if there is no such evidence, then you can always challenge that distribution and ask for a fresh distribution during the succession process, not after it's complete.
Jackie, is it okay if we move on? Are you
Sure.
happy?
Sure. No, I'm not happy. There's some questions that lawyers answer, and you're like, that's not the answer you wanted to hear. So, I'll move on. But
Yeah.
as I ask my question, also, I'm like, Viona, please put a place where people can contact you directly, because I know there's questions that are very specific to the different situations. So we would definitely, I'm sure there's ladies on here who would love to reach out to you on the side directly to handle their issues, face to face
Okay,
kind
so
of
I
thing.
can do that in the chat.
Irene,
Yes.
what's the best way to do that?
Yeah, chat, or Viona, if you don't mind, I can give people your contact details because I have them.
I don't mind.
Okay, so I will
Yes.
post in our socials Viona's contact details, but we can put them in the chat as well. Then
Very
you
well.
have two questions from Facebook from yes, and a card. If you can share with me a card, Sharon, good idea. If you can share a card with me, I can share with people.
Very well.
Amilo Jaber has two questions. One of her question is, the first question is, when you are buying a property like Great Wall Apartments, and the price I was given was from 4 million for a 2-bed apartment, is it worth it? Her second question is, I think this had been answered before, but I'll read it out anyway. What happens in a scenario where we bought land in 2018 and the guy now wants to sell our land to someone else, and the only docs we have are those from the chief because there was no title deed? Can we go to court?
Okay, let me start with the second question. By you saying the documents you have were those from the chief, I want to imagine these are the same documents Irene had mentioned before. The letters from the Ministry of Land, which were signed before a chief. I believe those are crucial documents that can be used in court against this person to confirm that a sale and payment of money to this seller had been done. However, you may want to find out if this seller has already gotten a title, and you may want to place a caveat or a caution on that property first, because you see, nothing stops them from selling the land once they have the title. And it's also because the government recognizes the registered right on the title. So if he ends up selling this property to a third person, and that third person takes possession of the property, for you will be fighting unregistered rights. So basically, what you will be claiming is a refund of money and not really pursuing the actual property that you had bought. But if the property hasn't been moved yet from the person who sold to you, the title is still in their name, then you may want to file a case in court using the documents that you got from the chief to prevent him from doing any sales. So that will stop him from actually undertaking a sale, and any third person coming to buy after that will actually be the one on the wrong. I don't know whether that answers your second questions. In terms of Great Wall, The rates I know for Great Wall, the last time I checked, the 4 million should be able to buy you a 3-bedroom apartment. But I don't know whether you are aware that Great Wall is actually facing financial challenges. It's one of those things I was talking about in the off-plan sale apartments. I know it's a project that built affordable housing for many, but they have had some financial issues, particularly depending on which phase you are buying into. So you may want to check that it's not one of those houses that is in the middle of a brawl between Great Wall and KCB, in terms of KCB trying to recover its money that they had lent to Great Wall during construction. I don't know whether I have answered her.
She says yes.
Okay.
So I'm not sure if that's to the first whatever, but yeah, she says yes. So I think we can give that a thumbs up. Jackie, can I hand over to you? Because I think time is really, we're sort of not good on time. So if I can hand over to you so that you can wrap up or you can make a decision on what you want to do.
Thank you so much, Irene, for moderating for us today. And thank you so much, Viona, for your patience and your time with us also. It totally depends on Viona also. Viona, are you ready for us to wrap up with you, or how do you feel? Ladies, would you like to, we have also Viona's direct contacts in case you have a issue that you want her to directly handle for you. I'm sure she'll do an amazing job for us. Viona?
On my part, I'm okay. If the questions are done, I wouldn't mind answering any more questions, but I'm okay if you're okay.
I actually do have one. Just I don't know if anyone has asked, because in general, I think people have asked in terms of their personal, like, but I want to ask something in terms of from a Sacco standpoint.
Yes.
If in future we want to consider probably people buying property through the Sacco. I mean, because we're growing, we're not there yet, but I think we are growing and we might get there at some point. From a legal standpoint, and you know what, you don't even have to answer this question. You can answer it at which point, whenever when we have that bridge to cross. But
Yeah.
I'm just wondering, do you think that it should be on a retainer basis or on a per job basis, like sort of going forward? Or do you think it should be considered based on volumes? What's your take on it?
Oh, okay. So if you were to start this, there is usually the pre-financing period where you are looking at your internal documents as a Sacco, or rather your internal processes for lending as a Sacco, especially when you are considering taking property as security for the loans that you are giving out. So we can do a retainer for purposes of advisory on your internal processes and legal processes. Yeah. However, the practice is that whenever a borrower is taking up a loan to do financing, not only in other Saccos, in the other Sacco forums that I have been, the cost of that financing is always on the borrower. So the Sacco doesn't pay the legal fees. What you do as a Sacco is that you will have a panel of lawyers who you can use for such transactions. And what you do with the purchasers is that, or rather the borrowers, you give them a list of these lawyers and they shop for where they can get the best services and the best rate. Yeah. So that it relieves that pressure from you in terms of negotiating the fees and the costs of that, registering that charge, and the legal fees for the advocate will always be borne on by the borrower. It's, however, always advisable now for the advocates who will be in your panel, I'm saying including me, hopefully you consider me worthy of being in your panel. We will give you like time rates, like the rates for the different levels of financing that you will be giving, so that by the time you're advising a borrower who is taking up a rate, you can comfortably tell them this will roughly cost you this much, so that even by the time they are considering to take the facility, they are well aware about the costs of that financing.
Okay. Okay. So what I'm hearing from you is that there's stuff that we need to do in the beginning for us to qualify as a Sacco that can give loans, mortgages, and that part is what needs the retainer.
Precisely.
Or okay, thank you. Thank you for that.
Okay.
Aching, you have a question?
Actually, I think Viona has touched a little bit on that on the question when she was responding to Brenda. So Viona, you know, Jowes is still a growing Sacco, and we have many women here who own land, and sometimes taking loan becomes very difficult because we are not able to get guarantors, right? However, those who have land would wish to kind of maybe use their land as a collateral. Maybe not today, or maybe just another day. If you can maybe walk us through on how that process of using the collateral to acquire a loan can look like, or maybe or just come and educate us as members and, you know, maybe the management to see what they can do, because I suppose that will really help increase Joe's loan facilitation. Yeah. So if you can, not today because time is out, but I know, and I know you are. I'm just saying this is off the record. Me and almost 100 other women here. We have Viona helped us with the registration and doing some land issues in Kenya. So I know you can do this for us for free at Joes. I'm just saying. But anyway, yeah, if you can just educate us on the process so that we kind of really understand the expectation and how what the process looks like, so that maybe in future Joes can start taking collateral and ladies can begin to take more loans to build this women's Sacco. And last, I would like to request you to join Joes. Thank you.
It has actually been on my mind. I was in that 7 o'clock session when they were talking to the new members, and I was asking myself, what are your requirements? And I saw I met all of them, so I will not mind joining, especially to be with people of my own, and participate even in growing the Sacco. The question that you've asked about using your properties as collateral, like I had mentioned to Brenda earlier, it is an internal process that Joes has to consider, especially because of the risk. I know it is something that would help the membership come in to take loans and have easier access to facilities. But there's also something that I would mention is that, you know, the loan taking business for the Sacco thrives best when repayments are done. Actually, the Saccos are never in a business of auctioning and selling people's properties. But in the past, since COVID season, most Saccos, especially in Kenya, have found themselves with properties in their portfolios, which were given as securities, and now they have to go through the route of selling. For any financial institution, when they are considering receiving a financial repayment in terms of cash money that is recovering from guarantors, or going through the process of auction or selling of units, they would choose the easier way out, which is going through guarantors, which is the easier way, because these are guarantors whose money you are already holding. The collateral property collateral process is a tougher conversation, and I usually see it requires the financial, in this case the Sacco, to have a very good base of capital, so that you do not, like, for them, and that's why I was saying it's really an internal conversation for the Sacco to look at its at its capital base to know how much it can set aside for giving loans based on collateral, because this is money that could come back immediately, and if it doesn't come back, you have to resell people's property, which is not a walk in the park. It's not that easy. We have several tiers of law to follow through before you can actually sell somebody's property. So I know your management is actually considering it if it was to open up the loan uptake process. Eventually it is profitable, but definitely any ease coming profit comes in with risks attached to it.
Thank you, Viona. I think I'll also ask a question. I don't know if I should ask it here. So I'll put whatever, because Viona is also my advocate in a certain property that I'm buying. So you'll know. You'll know why I'm asking some of the questions. So if you buy a property and you don't own, usually they have the residents association who own the title for the land, and you don't own the title, you don't have a residents association that owns the title of the land, are you opening up yourself to that land being sold and losing your property? What happens if the land is sold? Or as tenants of the land owning apartments, you have right to actually put register your rights on that title?
So it's in very, very, very rare circumstances that you find a management company, not a management company where the unit owners, where the apartment owners are shareholders, not owning the mother title. But if you dig deeper, you will see that this management company may actually be it's a structuring. Let me say it's a structuring that some of the very, very clever developers came up with, where especially where there is a mixed use development, where you have residential and maybe commercial and maybe any other, like a mall of sort. So you find each one of these users, like the commercial blocks, the residential block, each one of them has a representative that eventually is a party in that company that owns the management company. But be that as it may, if you ever find yourself in a situation where you own an apartment, but you do not own a share in the company that holds the mother title, just know that eventually, since your apartment title has been registered against the mother title, your rights in that property supersede any other rights that come thereafter. So in my view, any person who comes to sell should, in their due diligence, be able to see that, yes, I am being sold to this land. But when they come to the site, they can see the land has apartments. When they look at the search of that title, they can see that there are several purchasers who have titles tied to this. So that person who is buying from buying a mother title that has this kind of encumbrances has very, very limited use for that kind of a title, and there is very little they can do without having to consult the unit owners of the apartment. So this person cannot come eventually and just kick you guys all off and say, I own the mother title. No. And again, that is a problem that is currently being solved with the Sectional Properties Act that came through, where now the government is requiring that all of such projects, except the mixed user projects, at least give sectional titles to the unit owners to replace the leases that previously were being given.
Thank you, Viona. You've mentioned sectional title and you've reminded me of another question. Now I'm going to hog. Please, Jackie, feel free to kick me out if I'm hogging the conversation. So is that being backdated? Because I had
Um, um,
someone
um,
tell me.
before Viona, just because we are not kind of with over our time, if you're ready to stop, just tell when you're answering, just let us know. Hey ladies, it's enough for me, because as you can see, we are we have a lot of questions, and we're
Sure.
really enjoying the knowledge you're giving us. So if when you're ready to stop, just let us know. We do not want to overstay our welcome with you at this point. But thank you so
Maybe
very
what I
much.
can say, I can take the
Yes.
next 10, then I'll be comfortable to leave, so that at least we know we have that space of 10 minutes.
Thank you so much. Thank you very much.
So I'll ask mine on section. I've heard people talking about sectional title and saying that now people won't be given leases anymore for apartments. You'll get sectional titles. Is that being what is it? If it's easy for you to explain in a very short time, and then is that being backdated? Is if you own a lease now, is that going to be converted to a sectional title, or is it just from the day that a law went in play, if that's the legal term for it?
Yeah, so eventually, the government intends that all apartment owners with holding leases, regardless of when you got your lease, should eventually convert their leases to sectional titles. There's a whole process for doing that, which involves the management company of this project registering a sectional plan. So you get a surveyor who comes and he geo-references. So it's a lot of jargon there, but a surveyor needs to come and take the boundaries of your apartment, because you see now this is again a digital thing, that they should be now able to identify your apartment as your apartment, exclusive of all the other apartments within the land registry records. So the surveyor should come for built up apartments, whether new or old, create a sectional plan, register that sectional plan, and then now once the sectional plan has been registered, the unit owners who hold leases can now surrender their leases individually or jointly to the lands registry and replace them with sectional titles. Yeah, so that happens, like you're saying, it can happen retrospectively, not just for new projects going forward. But even as I say so, I want to put in a rider, and it's because I know where I've come with from you, Irene. And this is about mixed use projects. The law allowed a leeway for developers who are having large projects that are mixed use, whereby the mother title is not just for residential unit. The mother title has other commercial units and other functions within it. So for such management companies and developers, they are not required to submit themselves to the Sectional Properties Act. They can actually continue issuing leases. That's why you are finding like there are projects, and if you look at the projects where leases are being issued, they are mixed use. Yeah, but I in my mind, I usually say, at some point they will figure out how to probably ask these developers to either subdivide the land, or they change the law to a situation where, at least for residential units, they should be able to give sectional titles for each apartment. But we are not there yet for mixed use projects. But if you are buying from a project that is purely a residential project, yeah, a residential construction, then there is no other way. Actually, there are no leases being issued for any new apartments where the construction is purely residential.
Thank you, Viona. Viona had said 10 more minutes. So anyone else has any questions? Ching's hand is raised. I don't know if you have a question or that's a legacy hand. Aching? Okay, we can't hear from Achieng. Jackie, do I hand it back to you to wrap up then?
Are there anything? I'm not able to see if there's any questions on Facebook or on the chat. Are you able to check that real quick, and then we can wrap up?
Yeah, so there's no more questions on Facebook. On the chat, Alice has suggested, and we will request Viona. Alice has suggested if Viona could come back and answer some land legal questions at another time. She says the next education day. But Alice, we will request Viona. I think we've pretty much overstayed our welcome today, but we will request Viona, who will hopefully join us as a JOS member if she can come and answer our questions. Thank you. And that's it, Jackie.
Yeah, and I'm really so happy to hear that you're considering joining us.
Really.
Yeah, that is the most beautiful thing I've heard today, apart from all the knowledge I've gathered also. Thank you so very much, Viona. And we're looking forward to that. Irene, I need you to give let's do the next step of whatever Viona needs for her to become a part of us. And then we're really happy about that. And thank you so much for your patience and your time. And ladies, thank you for coming in today. Thank you for being actively involved. We normally have what we call Mdomo therapy after our meetings. Officially, I want to say we're officially done for our education day. And normally on our Mdomo therapy is just a time where we just kind of let loose, people come on camera. We're able to just speak freely and just, get off from the formal meeting time. So you're welcome to stay for a few more minutes, ladies, if you still have the time. It's still daytime in Texas. So for me, it's still a good time but I know in Kenya now, I don't even know what time of the day or night it is. But welcome again, and thank you everybody for coming. Is there anybody who would like to volunteer to pray us out for this official time? Any volunteers, please?
I can pray. Hello?
We can hear you, Lillian. Thank you. Go ahead.
Okay, this is Lillian. Then let's pray. Almighty Father, we thank you again. We glorify your name for the meeting that we've had, the productive meeting that we've had, Jehovah. We thank you for this group, Jehovah. We ask you to continue enlightening us, continue working on this group, Jehovah. Continue making us be a bigger group, a bigger circle, Jehovah. Father, we thank you for the attorney who was with us and the time that she's taken to be with us, Jehovah. It is not for free. It is not, we don't take it for granted. But we thank you, Father, for all that she's answered. Thank you, Father, for every ladies who are here and even those who didn't attend. Jehovah, we ask you to continue being with us until we meet again. In Jesus' name I pray. Amen.
Erokamana, Lillian. Thank you. And ladies, you're free to drop off if you want to. Those who want to stay on,